Finally, this is the detailed breakdown of the Sedina Tamakloe case, why the Court of Appeal justices, 3 of them unanimously ruled says she's been acquitted and discharged. Many of us have expressed surprise about the ruling, but this is what the laws are saying. And said I'll try to read 98 pages, maybe 30 pages. Nanam will office me Kofi Namusa Professor Kwekwaza actual a detailed summary of it. After I do the video, I'll put the summary in there. So for those who may want to watch and read, still football team no commentary bit my NSA. It's made the bro. When you finish, then you also share your view on the matter. And to make sure also subscribe. No click on notification. The video be to be and what to me be. Let's quickly go into the matter. Now, Sedina Tamakloe no yabon komona chirewa nenti court no 1 Obatampa microfinance patroti issue ni abasika bi 500,000 Ghana cedis me bobasam no so ma na maka ne court no kan on all these matters say no beti ase 2 na about on Daniel Axim sika bi omka so mo de koye sensitization program and also no ni 2 offense no 3 kantamantu yato wasika 579,800 Ghana cedis say often koma kantamantu dumfo ma na ejahye wom wadi. And again 4 ye so ko cars be 350 one for public procurement and share so na ko car no 4 5 about prices no de ko car ne bo no na susun dodo 6 mobile phones or kotoye 200 mobile phones or 93 Ghana cedis 412. Omuko shemu open price no na phone no 24,400. Na say wo bu aban no almost 70,000 Ghana cedis. 7 improper ex-gratia any leave payment or the money on the debt. So these are the 7 grounds on which justice Efia Sewa Saributwe a ruling here. My bro many kure move na a 78 count and a bobo case willfully causing financial loss to the state, improper disposing of public assets, money laundering, willfully causing financial loss to the state, stealing, conspiracy to steal, any idea the bobo now. As somebody called court, this is what the court said. The court basically said, say, grounds B to H, the count and the fact of the case were merely stated that the trial court erred in convicting Sedina Tamakloe without explaining the alleged errors. In simple language, it is not enough to tell an appellate court the judge was wrong. The appellant must explain how precisely the judge was wrong. However, striking out these 7 grounds did not end the appeal. The court still considered ground A, the broad complaint that the convictions were unreasonable and not supported by the evidence. Say, in Swan Sedina Tamakloe the court say, count the body 78 no. Nina swanim grounds anymore no court and appeals court and any way dream. Why were the appeals courts agreeing with the lawyers of Sedina Tamakloe? Almost say the court held that the several charges were manifestly defective because they did not provide sufficient particulars of the act, omissions, or transactions said to constitute the offense. This was not simply a complaint about poor grammar or the incorrect numbering of the counts. In a criminal trial, an accused person must be told with reasonable clarity what she allegedly did. A charge must not merely name the offense, it must provide enough factual detail to enable the accused to understand and answer the allegations. The appeals court in the first observation making is as a charges, ye pray when ye file ye do. Ye shadan chiresoka so bia cause financial loss to the state. A coin bear soon or far so cause financial loss to the state. San common charge sheet net me money yet muka then smart economic as yanko court no. Na me case a quarter. Brief facts na Attorney General de ban and no ye be hu offense ni ye. Samuka sana me kasa se scan coin we kwa one ye be hu say 55 and na 5.2 and answer 12102 one ye be hu. Appeals court say fact no ana e offense no we feel causing financial loss to the state ni oye nti a wo ka charge ni no sa nkomo no Attorney General no a o file asem no na se Godfrey Damo o ma anya sa charge sheet ni ye defective And the reason why I saw my charge it in so much trust and community about former accused person. I accuse no. And also to me in 1 year, that's what the appeals court said. The court goes further to say, however, the court did not simply decide the appeal solely because some charges were defective. It independently examined whether the prosecution's evidence proved the offenses. Now, this is what happened. So, when so when I say I'm filing the year, just said I'm funny. I'm confirmed all the evidences that the prosecution stood on, that the High Court decided on or sat on by Justice Efia Sewaboche ruled against Sedina Tamakloe. Or say, the central error in the appeals court held that the trial judge repeatedly reversed the burden of proof. Or say, several charges alleged that Sedina acted without approval. It's a PPA board no koto cast no. Say prove anywhere. The appeals court is saying that that burden of proof was on the state. That it was the state that was supposed to prove the evidence and only approval, but the trial judge and the prosecution shifted the burden of proof on Sedina Tamakloe. I find this interesting because in the one-to-me case, Justice Audrey Kokuvite, when it came to the reasonable that said that the burden of proof is that Attionu Bawumia abranti enentem. We say man to me say me koye garam say mama to me say to me koye reclamation. Then the judge went further and said that we say want to me say wa man is cancel koye reclamation so could do could be so 10 to 15 years could be see kaye the reclamation. So the judge inferred from want to me's answers that no, you have not been able to prove that. So I'm quite surprised. I'm not a lawyer, but based on what I've explained to you, that they are saying that the burden of proof at no point shift to Sedina Tamakloe, and that the state had to prove the burden. But when we all read the want to be trial here, so that is interesting. But again, I'm not a lawyer. Young Koso. Or say, the Court of Appeal held that this was wrong. A prosecutor cannot shift the burden of merely by framing an allegation negatively. So I don't know what kind of job say burden of proof at all times. Let's say state need to prove BBR or KBR. Sedina had no business to do that. Now it goes further. Say Obatampa 500,000. MASLOC come a company way from Obatamba besia 500,000. And on this can come Obatampa MD case. If it's one MASLOC de manon. Asun on timintua. It is hard there MASLOC imagine sika. And on this kind of good furious from Mkoba Sedina Tamakloe. Send me watch the penka video. That is here. Now, prosecution is a charge, a share offense in him. Court, paper, only prove the evidence said this kind of free to a good furious from the Sedina Tamakloe. A letter about Tampa Microfinance MD a prove letter trust a MASLOC who receive says can and letter Nindigo. It is state you couldn't provide that MASLOC copy of they receiving the amount in Intino and also in Semuno. TNE, Mamen Kaima, or say the prosecution's case was that Obatampa returned the 500,000 in cash directly to Sedina, and she acknowledged receiving it in a letter. The court found serious evidential problems. The original acknowledgement letter was not produced. The document tendered was a copy obtained from Obatampa. No corresponding MASLOC copy was produced, even though the reference number on the letter suggests that MASLOC should have retained one. The MASLOC official who testified had not seen an official MASLOC copy against which the document could be compared. The chairman of Obatampa also claimed that he had exchanged WhatsApp messages to Sedina Tamakloe when he refunded the money. Those messages were not produced. But the question here is that the prosecution case of Obatampa returned the cash to Sedina Tamakloe and she acknowledged receiving it in a letter. So if she acknowledged receiving it in a letter, it could also be possible that she took the letter. It is possible. So the staff for MASLOC testifying on MASLOC, it's possible they don't see how many low level staff. Me, you just say to. How will I see most of the correspondence between Kenansa and Jimmy Agla? How will I know? How will I know? So it's possible that possibly possibly, and I'm not inferring any input, that I'm just saying, say this kind of prayer said in Tamakloe. That appeals court is saying that the prosecution said she received it, she gave a letter, Obatampa has proven the copy of the letter, which shows that MASLOC was supposed to have a copy of the same letter. And if a MASLOC staff says that they've not cited the letter, that is enough to throw away that allegation against Sedina Tamakloe. I mean, those who are senior managers, there are many letters our HR have, I don't have. On me, you see to do. There are many letters in my file that I may not know. So it is possible that maybe she receiving the money and knowing possibly that she will divert the money, also possibly took care of the letter. Is that not possible? So I also find that I'm not the court. I'm giving you the ruling. Yankoso. Obi no can say, without proof of receipt, dishonest appropriation could not be established. The conviction and sentence relating to that money were therefore set aside. So the question is, 500,000 and then say, and one some Esiana. When you are telling you, because the microphone commands Steve Zando. And Steve Zando say, you microphone so Toma me 3,000 in there. Meet me talk. What I say? No, the man dear brave. Or the brave and the court now judge so when I'm a chief. Ye quite chileno, a year two, Bakunim. 7 na me back one, I'm not me start back on the day. Is that enough to say that Zandam farmer? And he Mike and a wing, 500,000 a wing? Also, but I'm patching letter say, but the idea buy. The letter is copied to MASLOC. Interesting. Let's go on. Or say, Cantamanto fire victim, dear no. TM Koso, Mayo Batampa. Mayanko Cantamanta 579,000 Ghana cedis. Or say, the prosecution alleged that Sedina dishonestly misappropriated 579,800 cedis intended for victims of Cantamanta fire market fire. However, one prosecution which admitted that inquiries has established that the fund had been distributed to the victims. Another victim had confirmed this to him. Although that information was omitted from the report tendered in the evidence, the court held that the admission struck at the foundation of the stealing charge. If the funds had been disbursed to the intended victims, the allegation of dishonest appropriation could not be sustained. The conviction and sentence related to the Cantamanta fire was set aside. Or say, however, one prosecution witness admitted the inquiries had established that the funds had been distributed to the victims. Another victim had confirmed this to him, although that information was omitted from the reported evidence. So I'm say, Obi admitted said victims. Let me move on. Now let's go to the money laundering accusation. Or say, these were set aside. Why were they set aside? The alleged stealing offenses were the underlying or predicate offenses supporting the money laundering charges. In simple terms, the prosecution first had to prove that the money was the proceeds of an unlawful entity. Once the prosecution failed to prove the relevant stealing offenses, it could not establish that the money was the proceeds of crime. The legal foundation for the money laundering conviction therefore misappeared. Say, prosecution entimian provises can we ankwade. So okase say sikana wentimian provises we are no kase waye walonda and tosum. That is also what the court is saying. Montwe na mefa power bank ni mission. Minister of Energy, Menya Brahman. Don't jina pono, Menya Brahman pa. Menya Brahman. Munjina son treme. Menya Brahman don't jina pono pa. Hey. Okay, let's go. Okay. Oh, Ghana. Okay, so that's that. Now the court did not lighten up. Now then, you Hunukran and Moodin is a okay, or say it was say Sika won't even prove where we are there. Unfuntimin Kase or Londa and Tossum. according to the court. Now let's go further. On the charge of ex gratia payments, say the court set aside the conviction for improper payment of public funds. MASLOC head of finance testified that his office processed and authorized the payment based on appointment document issued by the chief of staff at the office of the president. He said that he found nothing wrong with the document and authorized the payment on this basis. There was no evidence that Sedina personally authorized an improper payment, deceived the finance department, made a misrepresentation, presented false document, or caused a payment to be made contrary to an identifiable, verifiable procedure. And almost say, Sedina Tamakloe has gratia ne or no do at home, and a head of finance this kind of man or G. No, the question is on face camera, and I know also the question, head of finance, the chief of staff, and the troll let them so first is kind of man. Okay. Now, cast in the phone, so say the court and the council say. The prosecution alleged that Sedina made commitments amounting to approximately 61.7 million without authority and without following the proper procedure. The court held that the prosecution did not identify the applicable verification processes or demonstrate precisely how Sedina breached it. The evidence also showed that the Ministry of Finance had written to the Public Procurement Authority confirming that the financing arrangement for the vehicles were under consideration. It was not Sedina's responsibility to prove that she had authority. It was the prosecution's responsibility to prove beyond reasonable that she did not. Again, burden of proof say. So we say when ya PPA letter, the burden never shifts to Sedina Tamakloe. The state must always provide because you are alleging she didn't have authority. The Court of Appeal speaking. Now on the issue of cash payments, court and also can say, and yes, Sedina Sedina free on the 2017 MPP MASLOC by nice sticker. On by year renegotiation could 2 years canon. It is easy can the difference so that it's our home and one tansa a boss Sedina Tamakloe. This is what I can do for you on the summary of the almost 100 pages ruling. I think it to the best of my ability, and credit to Professor Kwekwaza, credit to him, credit to my lawyer. I mean, it's me read 30 pages, but no my bread, honestly. So all credit to him. Every analysis I've done for you on this is from him. And based on the 30 page, at least my fair knowledge about what I got from the 30 page, I think this is a perfect summary of the case. I think I've raised my issues or difficulty with some of the things because I know burden of proof can shift during trials. I know I'm not a lawyer, but won't be trial. When you read Justice Wadikwa-Kuvite's ruling, it's clear. But on the charges being defective, well, let me reserve my commentary on that. I'll leave the next commentary to you. And I don't know what to make of it. Whether maybe this changes your mind. Me, it hasn't changed my mind. There's a lot of unanswered questions, but I don't want to go into certain territories. I just want to control myself. And yeah, maybe not today. Maybe not today. But I'll certainly come back to this. Trust me on that. I promise you I'll do the reeling and I've done it for you. In tomorrow, so I'm say be a channel. Forgive me for that. Make sure say over subscribe. I'm more subscribe and click the notification. The video be at my home and wait to me. I should be. Make sure so much say that I'm here. Ghana and so here. Bye bye.